Thank you very much for coming out for this panel on the future of international justice. I'm Susan Waltz from the Ford School of Public Policy, and I'm going to be moderating the talk today. And I'll say right at the beginning that there are some cards that are around, and if a question occurs to you during the talk, please feel free to write it down, and we'll have a couple of runners. I think Laura is one of them who's going to be looking for people who have cards that they would like to pass up to the front, and we'll look at it and try to use that as a way of organizing the questions at the end. So I wanted to just say a few words by way of introducing the panel, because when I was invited to moderate this panel, it brought back a lot of memories. In fact, it's hard for me to believe it's been 25 years since the International Tribunal for Yugoslavia was set up. And what I have remembered very vividly was a moment in early August 1995 when I was in a meeting in Ljubljana, Slovenia, and watching CNN in my hotel room and seeing that mass graves were being dug up near Srebrenica. And at that point, we didn't really know what had happened in this safe haven, what was to have been a safe haven for people who had been victims of ethnic cleansing. The UN had designated a few villages that were to be safe places for them to flee. And Srebrenica was one of the villages that was filled up with women and children and older people. And as I'm intimating, ultimately some 8,000 bodies were exhumed from the surrounding area. And one of the things that I recall was that Amnesty International had sent a team of investigators to interview people who had survived, or who were still left standing, as it were, after the troops had retreated. And what impressed me so much from their report was that they had interviewed hundreds of women, and they did not find a single woman, I'm going to cry here, who did not have a missing or dead or presumably dead relative, male relative. Every single person they talked to could report that they had lost someone in their family in the preceding few weeks. It was a very powerful moment, and I remember talking to an international lawyer friend of mine who was with me at this meeting, and I said, Menno, you know, this International Criminal Tribunal for Yugoslavia, really, I mean, in face of what we're just witnessing, what good is it really going to do? I mean, the indictments, they can come down, but what's the chances of the people, the perpetrators, really being arrested and seeing justice? And he stood back in his, kind of Dutch matter-of-factness and said, well, Susan, these guys, they really, when they get sick, they really like to go abroad for medical treatment, and they really like to take vacations abroad, and at least they won't ever be able to do that again without fear of an arrest. And we talked about that being, better than nothing, we supposed, but not really knowing whether there would ever be any justice on the other side. Well, today's panel is in a position to tell us about the justice on the other side. I am very honored, and I think you probably feel the same, to have Dermot Groom here with us from University of Pennsylvania. He was the lead prosecutor in the cases, in several of the very prominent cases, including most recently the case of Ratko Mladic, but he also was prosecutor in the case of Slobodan Milosevic, the president of Serbia, and in some other cases that may not be as well known, but that set some really important principles of jurisprudence. And I think we're all very happy to hear what he has to say about the lessons learned. He's not going to be our first speaker. Our first speaker will be Bob Donia, who is a Michigan alum, and we're very proud of his role in these trials as well. He knows the languages of the region very well, at least Serbian, right? and was called in originally to do some translation and ended up being, I hope I'm not over-speaking here, but being a bit of a star witness in some of these trials because he was able to interpret and work with the material. And he and Dermot Groom worked together in some of these prosecutions. So we'll have Bob and then Dermot, and then we'll have Steve Ratner from our law school. He is the Bruno Sima Professor of International Law. Steve does a lot of work on various issues of international law, but rather than read you a resume, I'll say what I know best about him, which is that in the late 1980s, he was asked by Secretary General of the United Nations to look into war crimes that were committed in Cambodia and see what kind of prosecutions might be able to unfold to pursue justice there. And then about 10 years later, he was asked to look into human rights violations that had transpired in civil war in Sri Lanka. He has been on the State Department's Advisory Committee on International Law for about 10 years. So we're really happy that Steve will give us a little bit broader perspective on these issues. And then last, to wrap up and maybe give us the broadest yet perspective, is John Ciorciari from Ford School, my colleague at the Ford School and the director of the International Policy Center there. And John, for the last few years, has worked under or with the benefit of a Carnegie Fellowship to look at shared sovereignty in failed and failing states that are kind of in a recovery from many years of having gross problems with human rights and governance. And John, part of what led him into this was his own work in Cambodia as a legal advisor to the documentation center that was helping supply evidence to the tribunal there. So we have a really distinguished panel, and I'm sure that you're going to have lots of interest in what they have to say and lots of good questions for them. So we'll turn to Bob to start things off.
Okay, thank you, Susan. It's a real privilege to be on this panel with these three distinguished scholars and friends of human rights from the University of Michigan, and with Dermot Groom, as Susan indicated, with whom I've shared a number of experiences in the courtroom at The Hague. I think I can say we're both pleased at this time that there won't be three robed figures judging us at the end of this presentation we're making. Because I'm first, it falls on me to give you a very brief introduction to the ICTY. And to do that, I have to give you a very brief introduction to the wars in Yugoslavia. So this will be, I've been given 2 minutes to do this. So it will be, I would say, not short, not maybe even cursory, but freeze-dried. So here we go. In 1990 and 91, communism was collapsing in the Soviet Union and Eastern Europe. Several communist states were federations that disappeared as their component republics asserted independence, usually with only minimum violence, and became internationally recognized. Only in Yugoslavia in Southeast Europe did the leaders of these these republics, Serbia and Croatia, actively encourage and support their ethnic Serb and Croat kinsmen living in the republic located between them, which was called Bosnia and Herzegovina, and encourage them to partition that republic and participate in wars to create parastates at the expense of the most numerous group, the Bosnian Muslims, now known today as the Bosniaks. During those wars, nationalist Serbs and Croats expelled over 1 million Bosnian Muslims and members of other groups to create ethnically homogeneous Serb and Croat regions. UN and EU negotiators sought from the beginning to negotiate an end to the fighting and to the crimes, but for a long time without success. During those campaigns of forced expulsion, many crimes against humanity were allegedly committed, mostly by Serbs and Croats, but also by some Bosniaks. In May 1993, the UN Security Council created an ad hoc institution, the International Criminal Tribunal for the Former Yugoslavia, or ICTY, to punish perpetrators of those crimes, to deter further unlawful acts, and hopefully to end the war. The war in Bosnia-Herzegovina did not, in fact, end until 1995, after NATO and the U.S. had forcefully intervened. But the tribunal, located in The Hague, Netherlands, continued its work until just a month and a half ago, December of 2017. It indicted 161 individuals, tried 111, convicted 90, and acquitted 19. But because not all cases were completed, the Security Council established a residual body, the Mechanism for International Criminal Tribunals, to wrap up the unfinished cases and turn out the lights. The mechanism continues to function to this day and will function, I think, for some time to come. What I would like to do today is look at a part of the tribunal's operations that really is the organizational component of the tribunal, in particular the organizational model with which it operates. And before I start, let me say that the ICTY has achieved many successes and in fact has been an historic example of the application of international humanitarian law to a regional conflict with successful convictions of many of those accused. But I'd like to look at the operational model and characterize it and compare it to another recent trial, which was that of Hussein Habre, the dictator of Chad from 1982 to 1990, who came to power with the support, of course, of the U.S. CIA, and ruled with an iron hand and committed atrocities against his own people in large numbers until he was overthrown in 1990, and he fled to Senegal. His trial, this set off a long series of demands to try Habre in various forums, and eventually ended up in his being tried in a hybrid court of within the domestic justice system of Senegal, but with the participation of the Extraordinary Chambers of Africa, sponsored by the African Union. And I'm going to contrast these two trials to hopefully show, I think, first of all, where we're going, I believe, and also what some of the problems that the ICTY struggled with came about. So I'll characterize the ICTY organizationally as a UN-created, independent, largely self-governing body with a biennial renewable budget negotiated with the Security Council and held distant from the crime scenes, with jurists drawn from a global pool, but minimal participation from survivors and jurists from the region where crimes took place, with the exception, of course, of the accused, who were there against their will, and a large number of witnesses who came from the region. The Habre trial, on the other hand, that court was a regionally sanctioned shared jurisdiction or hybrid court within a domestic justice system. It had a predetermined budget. Before the first trial ever began, it had a predetermined budget of about $10 million US, and involved massive participation from jurists and survivors from the region and from regional and international NGOs. Let me start by comparing the costs. The ICTY, as we've said, operated over 24 years. It spent about $2.5 billion. It was a multilingual court in that the official languages were French and English, and the languages of the region were used when it was appropriate. That accounted for a substantial portion of the cost of the tribunals, interpreters, translators, and all the time that was consumed actually in the mastering of the change from one language to the other. In comparison, the Habre trial had a budget of 10 million US dollars, as I said, allocated beforehand, and it did not go over that budget. There were additional funds provided to the NGOs that operated in support of the court at various times. The duration of the trials. The ICTY, of course, lasted for 24 years, covered a large number of trials. And the mechanism is destined to last, I think, at least another 5, perhaps longer, before it's all shut down. The longest trial was that of the so-called Croatian 6. It lasted 11 and a half years from the first bang of the gavel to the final appeals decision. And it is likely to be eclipsed by the trial that Dermot and I worked together, and I testified in again at the retrial just last week, which is that of the 2 senior Serbian police officials, Stanisic and Simatovic. That began in, I think, 2006, and so we're still counting from that. The Habre trial, the trial itself lasted 10 months. Shortly after that, a verdict or a judgment was issued, and the appeals judgment was issued in April 2017 for a total of 21 months running from the first gavel to the actual delivery of the appeals court. Proximity was very important, but geographic proximity was relatively the same. It's actually further from Chad to Senegal than it is from The Hague to Sarajevo. However, there was a great linguistic difference, of course, and a difference in the composition of the trial chambers, whereas in the Habre trial, both countries have French as an official language. So the trial took place in French, and there were no translation issues to speak of in the course of the trial. In addition, the physical distance in the case of the Habre trial was bridged by a great deal of travel back and forth by court participants and journalists and other people who were following the trial. The judges actually visited Chad and visited the crime scenes before the trial ever began, took witness statements, and viewed documents. And in addition, the full proceedings were carried on Chadian TV, and the court paid for journalists to travel to Chad, from Chad, to cover the trial. There was a big difference in documentation. I'm just going to say a word about this and let perhaps it be carried further in the discussion or by others. The Habre trial, almost all the evidence was gathered well in advance by survivor groups and NGO representatives. In 2001, and this is well before the trial, Reed Brody of Human Rights Watch found tens of thousands of documents in an abandoned headquarters, which included surveillance reports, death certificates revealing that over 1,200 people had been killed and 12,000 tortured, and personal communication from Habre indicating that he had received over 1,200 direct communications about 900 detainees, some of them with handwritten comments on the margin, which was not smart. And including one order that said, from now on, no prisoner of war can leave the detention center except in the case of death. Now, I think I can say that there isn't that kind of direct linkage documentation to any extent in any cases in The Hague. There's a lot of documentation. 10 million documents altogether have been assembled. And Dermot has had the misfortunate experience of having to go through an awful lot of them, and I've had to go through some of them too. But the nature of the cases has been far different from that kind of a direct link, because all of the cases have involved what amounts to a conspiracy theory, joint criminal enterprises, and meant weaving together an entire story about the history of the leaderships over a period of 5 years, rather than this kind of very specific documentation. I'll stop there and see if there are other questions, but
Great, we can
Go
take
ahead.
that up after.
okay.
Well, thank you to the International Institute for your kind invitation to participate in this roundtable. I've been asked to talk about the legacy of the ICTY. I certainly consider myself very fortunate to have had the opportunity to lead the prosecution of 5 ICTY trials and to supervise 6 investigations during my 12 years at the court. When the Security Council adopted Resolution 827 in May of 1993, I was amazed by this bold initiative to hold senior leaders to account for their role in atrocities, with the belief that this would facilitate an end to the war. This was revolutionary. No one expected it would succeed or last. By the time the ICTY concluded its work last December, the expectation had changed. The expectation now is that we should and must make every effort to hold those who commit international crimes accountable. This is real normative change and a fundamental part of ICTY's legacy. This normative expectation of accountability born at the ICTY first spread to the ICTR, then to courts for Sierra Leone, East Timor, Lebanon, Kosovo, and it probably helped the Rome Statute cross the finish line in 1998. This is the first point about ICTY's legacy that I'd like to tell you about today. And even though we appear to be in a period of contraction for international justice, we're not going back to a time where an expectation of impunity is the norm. The second is the body of law that the ICTY created. Crimes in the former Yugoslavia began in 1991. When the Security Council promulgated its Statute of Crimes in '93, it created an inherent ex post facto problem. The criminal statute came into existence after some of the crimes had been committed. The only way to remedy this was to embed within the resolution a requirement that there could only be convictions for crimes that already existed in international customary law. An imprecisely expressed, somewhat amorphous body of international customary crimes. Sure, everyone knows it's a crime to shoot an unarmed civilian, but what are its definitional requirements? What is the actus reus? What mens rea is required? It was incumbent on judges to excavate and then articulate the elements of these international customary crimes. Crimes such as torture, forcible transfer, sexual slavery. Ganel Moutreau, a judge at the newest incarnation of international justice, the Kosovo Specialist Chambers, calls the ICTY the midwife of our modern definitions of international crimes. Third, and perhaps one of its greatest legacies, is its generative force on the overall project of international justice. We investigated and prosecuted dozens of perpetrators, but we were only scratching the surface. But what we started subsequently became rooted, however tentatively, in other jurisdictions. During the Milosevic trial, we obtained the Scorpion Unit video showing men and boys from Srebrenica being murdered from the cameraman's lawyer. Once we took appropriate security precautions for the cameraman, we gave that video to investigative judges in Belgrade. They used it as the basis for a comprehensive investigation into the Scorpion Unit and ultimately convicted all of its members, abruptly countering Serbia's denial that Srebrenica happened and strengthening its special court in the process. ICTY prosecutors and investigators regularly conducted trainings to build local capacity. But apart from whatever direct help we gave to courts in Bosnia, Croatia, or Serbia, we began to see investigators and prosecutors from around the world requesting access to our evidence. investigating perpetrators who quietly settled in their cities and towns. There was an empirical study published in the American Journal of International Law last summer that found that in countries where the ICC is active, there is an increase in human rights litigation before domestic courts. Today, a synergy exists between international and domestic efforts to hold perpetrators of atrocity crimes accountable. Back in 2000, when I was leading the Milosevic Bosnia investigation, none of us believed he would be arrested. We thought that the ultimate utility of our work was to gather and preserve evidence for historians. But when, in 2001, our surprise, we had him in court, we proceeded through the trial. I had a deepening appreciation for just how important this fourth aspect of our legacy was, the historical record. Now, to be clear, the ICTY did not and could not write a comprehensive history of the conflict. What it could do was establish the facts alleged within the framework of a particular indictment, establish them with evidence tested in an adversarial process, and establish the material facts to a high standard of proof beyond reasonable doubt. But our most valuable contribution to history is the corpus of evidence that we leave behind, and evidence that only we could get. Historians cannot force someone to talk to them under oath. I could. They could not go into an archive and seize documents. We could. I could exercise my powers as a prosecutor to compel the production of evidence. I'm sure Bob remembers our shared excitement as ICTY investigators were able to get more and more transcripts of the Republic of Srpska assembly, each revealing a deepening, nuanced understanding of events. Wow, to see the words of Mladic and Milosevic in black and white, to read Mladic's verbatim statement before the 16th Assembly session when they asked him to ethnically cleanse Bosnia. He said, "People are not keys in one's pocket that can be shifted from here to there. People, this will be genocide." Through litigation, we compelled Serbia to provide the transcripts of the Supreme Defense Council, something akin to our National Security Council. All of this evidence, thousands of pages of witness testimony, over 9 million documents of documentary evidence, preserved for historians to exploit for decades to come. I must say I was disappointed today to hear Bob tell me that him and Richard Wilson's great effort to ensure this evidence collection is accessible has hit some impediments. It would really be a tragedy if this evidence, this body of evidence, is not made fully accessible. And lastly, 5. When we began the Milosevic trial, we were embarking on a massive trial. Crimes described in 3 indictments spanning 2 wars, 4 countries, and 10 years. To prove the allegations with the same quantum and quality of evidence required before national courts would not be possible without procedural innovation. The ICTY brought together trial procedure from the civil code system, a scientific judge-led inquiry, and the common law system, an adversarial battle presided over by an impartial judge. Each had advantages and disadvantages for our work. ICTY courtrooms, unencumbered by tradition or established practice, became the laboratory where we would create an amalgam, a new trial procedure for international trials. In the beginning, it felt a bit like building a car from the cobbled parts of a Ford, a Peugeot, and a Subaru, but we did it, and it drives well, met international standards, and has been adopted by other international courts. But with all that was accomplished, we must acknowledge where we failed. We have not been the progressive force of reconciliation we had hoped for. Unfortunately, deep societal fractures remain. I suppose we naively believe that being founded in the spirit of Chapter 7's mandate of peace and security, we could, in fact, restore it. But maybe it was too much to expect in a war started and maintained through weaponized narratives of what happened during World War II and what happened on the field of blackbirds in 1389, and so many other tragic Balkan stories in between. Perhaps the most important thing that we have given the people of Bosnia, Croatia, and Serbia in this regard is proof positive that their problems cannot be solved with the blood of their children. Would the Security Council establish the ICTY today if it were called upon to do so? The sad reality is probably not. It has certainly failed to address the crimes in Syria. We have far to go on the journey that Nuremberg and then the ICTY started. The ICTY, the court that holds the greatest potential for true international criminal justice, is stumbling. Some countries are contemplating giving up on the project. But no matter how difficult the challenges, we must always keep in mind the words of Justice Robert Jackson as he opened the Nuremberg trial, describing why we do international justice, why we prosecute atrocity crimes. Quote, civilization cannot tolerate their being ignored because it cannot survive their being repeated, unquote. Perhaps the most important aspect of ICTY's legacy is its reaffirmation of the importance of international justice and demonstrating that it is possible. Thank you.
Thank you very much. Thank you very much for the introduction, Susan. I'm really glad to be here. I'd like to express my particular pleasure to be on the podium with Bob and express my thanks to him for all he has done to promote the study of human rights at the University of Michigan, for which I'm personally and all of us are very grateful. I guess I'd like to start with sort of the glass metaphor about whether the glass is half full or half empty. And in my view, the glass is not half full. It's like 5% full. It's 95% empty. And that might be discouraging to some of you in this room. But you have to remember that before the ICTY, the glass was completely empty. Or maybe more accurately, there was no glass at all. Whatever glass there was at Nuremberg had been shattered by the Cold War. And it wasn't until this small moment at the end of the Cold War when the superpowers were able to get together and agree on some things that we had this opportunity to create the ICTY and its legacy. I'm going to, I think that, Dermot must have gotten a copy of my remarks because he, just said about a third of what I'm going to say, but so I may just say what he said slightly differently, but I hope I'll be able to add to his wonderful remarks. And I want to talk about the legacy of the tribunal beyond the obvious key accomplishment of the conviction of nearly 100 defendants, including those at the highest levels of responsibility for the atrocities in the former Yugoslavia. And in my view, I see 4 positive legacies and 4 less positive legacies, or maybe even negative legacies. First, I completely agree with Dermot that one of the key legacies of the tribunal is that individual criminal accountability is now seen as a necessary and realistic complement to accountability of states for human rights abuses. The traditional paradigm of human rights law developed after World War II, for the most part with the blip exception of Nuremberg, was that we were going to try to hold states accountable. The ICTY brought back the notion from the Nuremberg period that it was also important to hold individuals accountable because there were difficulties in sometimes holding states accountable, and there were additional advantages of holding individuals accountable. And that is now well regarded as part of the toolbox of responses to gross violations of human rights and humanitarian law. Secondly, I would also say the ICTY deserves credit for the proliferation of other methods, but not just the other courts that Dermot and Bob talked about, namely the other international courts, the other hybrid tribunals, and not even the other domestic courts like universal jurisdiction in the East Abre case, but also all the non-criminal methods such as truth commissions and commissions of inquiry like the one that I served on for Sri Lanka. Because those are part of the toolbox of accountability as well, even though they're not criminal. And they owe their their prevalence in recent years to the Yugoslavia Tribunal as well. Thirdly, as Dermot said, and just to put a slightly different spin on it, I think the jurisprudence of the tribunals is absolutely critical. Not just critical to me as an international lawyer because I read some of the cases, but it's critical because it's jurisprudence that is cited even in domestic courts. Indeed, it's jurisprudence that's been cited in U.S. courts, not just about elements of war crimes, but about issues of criminal law generally. Because the tribunal is not just a tribunal for trying international crime. It's not just the international part of the crimes. These are crimes where you need people like Dermot who are criminal prosecutors and to do the arguing, and you get judgments that are criminal law judgments as much as they're international law judgments. And those have a tremendous traction in domestic courts, and that's a very important legacy. And finally, I think the tribunal has a particularly important legacy on international law as a whole. We've seen, and I'm talking about international law outside of the context of the criminal justice in international law. So just to give some very, very brief examples, the idea that amnesties are blanket amnesties or self-amnesties or amnesties for crimes against humanity are no longer acceptable in international law, which played itself out very recently in the details of the Colombia Peace Accord, for instance. That's a notion that I think owes itself to the ICTY. Obviously, it's been reflected through regional human rights courts and UN bodies, but in many ways it starts with the idea that the tribunal, of course, could not and was and consider any amnesties. And this idea that, well, actually international law should really not take these amnesties all that seriously because they're usually self-serving. In international humanitarian law, it's not just the elements of war crimes themselves that have been elaborated by the tribunals, but just the elements of what the duties on states are under international humanitarian law, understanding what an indiscriminate attack is, understanding what a non-international armed conflict means. We owe a great deal to the International Criminal Tribunal for our understanding of these core elements of humanitarian law. But in other areas of law, the law on the use of force, to understand what is allowed, what a state is allowed to do and how it's allowed to respond, the law on international institutions, because these were, after all, international institutions, the role of the Security Council, the powers of the Security Council. Our understanding of the powers of the Council changed radically as a result of its creation of these tribunals. There used to be a debate about could the Security Council even create an international criminal tribunal, and it was litigated at the tribunal, and now we don't even ask that question anymore because we know the answer is yes. And so our understanding of the Security Council has changed as a result of this tribunal. The fact that it can create new tribunals, the fact that it can pick judges, these are all things that have, its power has come to have a new understanding as a result of the ICTY. So what's on the other side of the ledger? I guess, because it's been a while since I was a government lawyer and I've been in academia for a while, I have maybe a bit more skepticism about some aspects of the legacy of the tribunal. First, just one that Dermot mentioned, which is the very disappointing legacy with respect to the change of a narrative in the former Yugoslavia. There are many empirical studies now about this. A recent one by Marko Bolanovic, a Serb scholar who has an LLM from University of Michigan, who wrote a very, very pessimistic account of the ICTYs legacy in former Yugoslavia. And that, of course, is one I think that the practitioners at the tribunal would certainly share. Secondly, I think if anybody had some notion that international criminal justice, that the tribunal would, and the international other criminal courts would create what we might think of as a general deterrent effect. That is a deterrent effect beyond the specific set of cases that it was meant to deal with. I think they've been very disappointed. It's possible that the tribunal had a deterrent effect within Yugoslavia, although we do have to recall that Srebrenica happened 2 years after the creation of the tribunal, so even that's questionable. But the idea that the creation of multiple tribunals would have some kind of a overall positive effect on human rights, I don't think I don't think you can take that claim seriously. And again, I don't know how many people really, I don't know, how prevalent the view was, but you certainly, I think, had a lot of idealists who saw international criminal justice as having this effect. And I think it's, although there are certainly there's plenty of anecdotal evidence and interesting research about how certain warlords in certain civil wars have not engaged in certain atrocities because of fear of prosecution. I agree that there is evidence to the contrary. The overall pattern is not that encouraging. Thirdly, I think there has been a shift of both human and political capital away from holding states or groups responsible for atrocities, violations of human rights and humanitarian law. And I think that shift of human and political capital is seen through the enormous amount of resources put into international criminal justice at the UN, by governments, and by NGOs. And I think that there is a lot to be said still for holding states and groups accountable. I think there's a lot to be said for the traditional method of going after them through sanctions. And when political capital or human resources are diverted to tribunals, when you have lots of really smart people who focus on the ICC or the ICTY, that's fewer resources for other sorts of methods of accountability, which are also very important. I also think it's led to a switch in terms of looking at non-criminal methods of accountability, such as reparations. And again, the focus on criminal justice as the sort of highest justice, I think, misses out on the other aspects of what some scholars have called transformative justice. And I think there's a really interesting debate you can have about whether criminal justice is the highest form of justice. And finally, and relatedly, I think the legacy of the tribunal is, in a sense, to lend further support to what one of my mentors called something called judicial romanticism, which is the view that is particularly prominent in my field, maybe not in the world of IR that Sue does, and human rights practice that Sue and John both do. But in the international law world, there is this view that courts are the ideal method for solving problems. And I fear that the tribunals themselves may have perpetuated this judicial romantic view, and thus taken, in a sense, taken our eye off of the importance of things like non-judicial remedies, but also from things like prevention. Ideally, the tribunals, if they had been a deterrent, they also serve a preventive purpose. But my concern is that we may be getting away from prevention. I've always been of the view that the most important aspect of the human rights practice is a preventive practice up front. And obviously, accountability after the fact is important. But if there's only a certain amount of resources, one could make the claim that they're being taken away from prevention. At the same time, I don't want to be too smug about this. I mean, you can't assume that if we were to devote less resources to punishment of human rights abusers that they would be put into the box of prevention. They might just be spent on, new aircraft carriers or maybe, God willing, new development assistance, but it's not to say they'd be spent on methods to prevent human rights abuses. So I don't want to be too confident of that view, but I do think that all of us who work on human rights need to think beyond courts. Thank you.
Thanks. So I'd like to pick up on and elaborate on a theme that a few of my colleagues have already mentioned, which is the ICTY's relevance to other tribunals. In particular, I want to talk about hybrid tribunals, that is, tribunals that entail some mixture of domestic and international laws, procedures, and personnel. And so I'll briefly comment on the ICTY's influence on hybrid courts. I'll make a few comments on where hybrid justice has worked better or worse and why, and then close with a few thoughts about the possible implications for designing new or future hybrid courts. First, on the ICTY's influence, hybrid courts were basically rationalized from the outset as an effort to capitalize on the strengths that you've already heard about, namely the ability to deliver justice meeting international standards and high levels of technical sophistication, strong bases of evidence, at a lower cost and sometimes closer to the survivor population. and perhaps with greater local ownership and local legitimacy. And in that respect, the evolution of hybrid courts, or the birth of the concept of a hybrid court, owes much both to the strengths of the ICTY and also to perceived shortcomings of the first of the two models that Bob Donia outlined, a sort of sui generis, large brick-and-mortar institution that operates more or less autonomously outside of a national judicial system. In reality, so that's the marketing for hybrid courts. In reality, hybrid courts tended to come about as a result of political compromises, very often with the advocates of international criminal justice in given contexts advocating courts that looked more like the ICTY model, but forced because of donor disinterest in footing the bill or resistance from the sovereign authorities to adopt sort of measures in between. The very first example of this was in the discussions between the Cambodian government and the United Nations in the late 1990s, following the report that Steve and his colleagues had issued in early 1999, in which then Senator John Kerry and others mooted the idea of a middle ground between a fully domestic and a fully international process. That later came to pass in Cambodia, and there are also a number of other hybrid courts that are more really diverse than similar in many respects, but have this overarching shared characteristic of a mix of international and local personnel and often laws and procedure. So it's already been referenced by my colleagues, but I'll mention them again so that you have them in mind. There's UN-backed tribunals created for Sierra Leone, for Lebanon, for Cambodia. There have also been hybrid courts created during periods of UN administration in Kosovo and East Timor. There have been other models that don't involve direct UN participation, such as in Bosnia and Herzegovina and in Senegal that Bob mentioned, and more recently an EU venture with the government of Kosovo also, which has been mentioned already. Last but not least, there's a brand new hybrid court taking shape for the Central African Republic that's a partnership between a UN peacekeeping mission and the government of the CAR. The ICTY has been a progenitor, directly or indirectly, for many of these hybrid ventures. I believe Dermot mentioned the metaphor of a midwife, and the ICTY has performed this function in a number of respects. In some cases, hybrid courts have been created as direct complements or offshoots of the ICTY process. For example, the hybrid panels created by UN transitional administrators in Kosovo involved the inclusion of international judges and prosecutors alongside Kosovo counterparts for certain inter-ethnic crimes that were sensitive and that weren't covered either by the ICTY's mandate or that fell outside of the ICTY's resource capacity to be able to handle. In Bosnia and Herzegovina, a hybrid war crimes chamber was established pursuant to a 2005 domestic law that was explicitly part of the ICTY's completion strategy, and it's handled some cases referred by the ICTY and also some that were instigated locally. Generally speaking, lower level perpetrators from the conflict. In other cases, the ICTY has furnished hybrid courts with many of their best trained personnel, and there are many examples. I'll just mention a few. A former prosecutor and registrar at the Special Court for Sierra Leone had much of their training at the ICTY. Some of the key Sierra Leonean figures at that court, in fact, the only Sierra Leoneans who had experience, substantial experience in international criminal justice, had gotten it at the ICTY. The first president of the Special Tribunal for Lebanon was Antonio Cassese, who also was the ICTY's first president, and prosecutor Norman Farrell also brought lessons from his experience, I presume as a former colleague, a long time of Dermot's. Ditto for people like prosecutors Andrew Cayley and Nicholas Kumjian at the Khmer Rouge Tribunal. And so there's a very important sort of institutional evolution that simply comes from the ICTY spawning people who have expertise in international criminal law and practice. The ICTY has also been the source of a lot of the jurisprudence applied at hybrid courts, as others have mentioned. Just to give you a very crude sense of this, if you read the trial and appeals chamber judgments for the first case at the Khmer Rouge Tribunal, the trial chamber cites ICTY rules or decisions 121 times, and the appeals chamber cites them 167 times. And it's on a whole range of issues, from the means of practicing day-to-day in the courtroom to high-level substantive questions about how to think about superior responsibility, or this notion of joint criminal enterprise that was mentioned, that is sort of an extension of conspiracy doctrine. Or whether one's talking about issues of how to question a vulnerable witness. So much of what has been decided legally at these various hybrid courts has referenced or used as a lodestar jurisprudence from the ICTY. When hybrid courts have devised their rules of evidence and procedure, in a number of cases they've used the ICTY rules as an explicit precedent or as a model. And so there really are a lot of ways in which the ICTY has helped to generate this growth of the enterprise of international criminal law through institutional diffusion in various forms. Hybrid justice has not always been a success, though. There have been real ups and downs from case to case. And the performance, of course, depends a lot on idiosyncratic factors, who key personnel are on the bench, or prosecutors and defense lawyers. It also depends on the difficulty of the case, the operating environment, the linguistic environment, and other factors. But I think we can say at a high level that a few factors tend to set the stage for more or less successful processes. One is that international donors have to put in strong and sustained resources and political capital to make hybrid courts work. And two, domestic leaders have to be able to contribute at least some modicum of capacity, and more importantly, have to subscribe to and support a reasonably even-handed judicial process. When those ingredients have been present, we've had relative success. So the UN-backed Special Court for Sierra Leone was a treaty-based court where the Kaba government supported it, the parliament ratified the treaty, there was relatively strong domestic elite support for the venture, even when a sitting government cabinet member, Sam Hinga Norman, and a national hero who had defended the government at one point against rebel attack, was brought before the court and later convicted. It managed to weather those storms. Even when Charles Taylor became a former head of state, tried and then convicted by the special court, there was a political foundation that supported the effective jurisprudential work, as well as the outreach and other initiatives by the special court. The result, 92% of Sierra Leoneans surveyed say that it helped to deliver peace, and similarly high figures had a generally positive attitude toward the court. I don't want to suggest that everything at the special court worked perfectly, but I think we can say in relative terms this was a very successful venture, one that built in very useful ways on the ICTY model. I think we can also say a very different kind of court, something a little bit more like the model that Bob Donia was discussing, something more rooted in the domestic system, that is the Bosnian War Crimes Chamber, has also been reasonably successful. 150 plus cases have been adjudicated at a much lower cost than a fully international court. Many of the reports on the War Crimes Chamber have found that it has met, if not meeting the identical standards of jurisprudence to the ICTY, at least significant improvements on what might have been the case through a purely domestic process. The exit strategy for internationals at the War Crimes Chamber is still difficult to map out, but to date it looks like a relative success. By contrast, the Khmer Rouge Tribunal has run into a lot of problems, in large part because the Cambodian government signed up to support trials against a particular, very narrow set of defendants, and has opposed publicly and heavy-handedly the prosecution of others who reasonably might have come within the court's jurisdiction. The special panels of East Timor were largely a failed exercise in international criminal justice because there was so little resources put into the venture on the UN side, and so little capacity and also less eager ownership on the domestic side. And so that hybrid court sort of withered to a close in 2005 without having completed a large majority of its cases and without having convicted any of the big fish from Indonesia who were implicated in the atrocities in that country. The Special Tribunal for Lebanon is mired in problems related to that country's domestic politics because, to make a long story short, there are two major competing political factions, one of which is is ascendant, at least in terms of military power, and arguably is the ringholder led by Hezbollah, and opposes the tribunal, and therefore the tribunal hasn't been able to apprehend any of the suspects, and it's questionable as to whether the tribunal will ever issue a verdict. So going forward, when you look at some of these pluses and minuses and the factors that tend to inform successful hybrid justice, I think we can say that the political conditions that favor effective sui generis international or hybrid criminal courts are pretty rare. As laudable as the pursuit of international criminal accountability is, any effort to devise new mechanisms has to take account of some of these political realities. That is not to say to bow to them, but at least be very cognizant of them in trying to design effective mechanisms. So I mentioned the new hybrid court in the Central African Republic. It's not auspicious. So far, donor interest has been weak, only about $5 million raised. A small fraction of what will be necessary for even the first few years of the court's operations. Domestic capacity is anemic, and there are good reasons based on past practice to doubt that senior sitting officials are going to be committed to prosecutions when it doesn't serve their political interests. There's also been a lot of discussion about a hybrid court in South Sudan featuring African Union participation. Recently, in December, the government signed an agreement with the African Union to be able to set that up, but there's been a lot of foot dragging, and the latest iteration is that the South Sudanese parliament is sitting on that agreement. There's a lot of domestic reluctance, including from the defense minister and other powerful members of the government, and not too much regional pressure from surrounding African states. I'd say it's far from clear whether that hybrid court will even happen. In Sri Lanka, the Sirisena government has beaten back plans for a hybrid war crimes tribunal to adjudicate the kinds of offenses that Steve and the Commission shed so much light on after 2009. And proposals also exist for hybrid courts to deal with war crimes in Syria. And here the model explicitly adopted is something like the Hissène Habré trial in Senegal, that there would be a neighboring state that would have, that would exercise jurisdiction with Syrian participation to look at crimes committed by the Assad regime and others in the Syrian conflict. That also faces very steep political obstacles to being actualized. So in closing, the ICTY helped to create and to foster a body of law and a community of people with the capacity and the commitment to be able to advance international criminal justice norms. But the ICTY emerged in a very different international political landscape, and how its legacy gets carried forward, including through hybrid courts, is going to hinge greatly on whether key governments, including the U.S. government, decide to invest more of their political capital in transitional justice.
A very warm thank you to all the panelists for this very stimulating and thought-provoking discussion. And I have a question that I want to ask of all of you, but before I do, are there those of you sitting with cards that you would like to, I see one here, there may be several others, and those will be brought up, and I'll look at those really quickly. But in the meantime, let me try to frame this question. I listened with great interest at all of the comments about the instrumentality of the courts, what they had led to, and that is in fact what we ask you to do, to talk about the legacy of the courts. And I wondered, while I look at these questions, if you might address a more proximate question, which is, how did it feel to see, to all four of you actually, to think of the various perpetrators of human rights violations and crimes who have come before the courts and been prosecuted and perhaps convicted? Have you felt that justice has been served? Because it seemed to me that in the presentations, this more close-in kind of a part of the legacy wasn't really, prominently discussed. We are thinking about the long-range impact of the courts. And I recall, as we were just walking the room, you said that the Mladic, there's been some recent developments in that case. So what is it, what are you, maybe we'll start with you, Dermot, as in response to that, if you don't mind. And then I'll ask if any others have comments on that, and I'll look at your questions.
I think generally, I think my sense is justice has been done. It was a terrible disappointment for me that Milosevic died 4 weeks before the end of the trial, I mean, with all the time that we put into it. But apart from that, I think justice was done. I guess I'm reminded, when I listened to Susan's question, in the Milan Lukic case, he's one of the most awful perpetrators. 2 different occasions put women and children, 65 in each house, burnt them alive. He was a serial rapist. He did awful things. Just before we went to trial, he served alibi notice. He wasn't there. And when I had my investigators look through our evidence collection, what they found were that he was raping women on the same days that he was committing these crimes. So we learned this just before the trial started, went out, spoke to all of these women. They had not cooperated initially because of a lot of different reasons. Primarily, they were so traumatized, but they all agreed to come forward. And I tried to amend the indictment just before we started the trial to include the rapes, but was denied. They testified, the court came in, believed them, the alibi was broken. I went out and talked to each of those women and asked them, did they want me to refer the case to the court in Bosnia? And each one of them said, no, justice has been done. I don't want to do this again. And I really do feel that even though there's not a conviction for rape, justice was done by the conviction of Milan Lukic. So I take that as some measure that the justice was done.
I have pretty much the same viewpoint. I run eagerly to see what the judgments are in every one of these cases, whether I've been part of them or not. And I think it's very satisfying to me to see the convictions of those people who really were the worst people in this war and these atrocities. And likewise, I'm deeply disappointed when I see what I think is an unjust acquittal based on what the judges found, which has happened in several cases, including a couple that we've been involved with together. So yes, very much so. I feel a great sense of, I'd have to say, even personal satisfaction. And I'm very pleased when this happens. I think I would say, however, that I'm disappointed in a lot of the sentences, which are, to me, remarkably brief and are made further brief by considerations which basically say that nobody serves more than 2/3 of their term. And the fact that many of these convicted people have already spent a good number of years in jail. So by the time they're convicted and they get credit for time served, many of them just walk out the door. And I don't know, that I'm offended by that. But I think in general, in answer to your question, justice has been done in so many of these cases.
Thanks. I guess I would say that criminal justice was done. And I think, Bob, your point about the sentencing is also about the difference between American and European attitudes about sentencing for serious crimes. Mm-hmm. Or maybe at least generally non-American attitudes. I think, though, that justice is a much broader concept than criminal justice. And if we look at a sort of more victim-oriented approach to justice, which is not quite the same as what criminal justice is about doing, then there are many injustices that remain in terms of the victim's perspective, lack of reparations, lack of apologies, lack of psychological counseling. And so I think that a more victim-oriented, holistic approach is necessary for the aftermath of atrocities.
Yeah, I'll answer with reference to a specific day. On July 26, 2010, I was standing outside the courtroom when the first case ended at the Khmer Rouge Tribunal in Cambodia, and the guy who was on trial was Doik, who had been the chief of the Khmer Rouge secret interrogation and torture facility in Phnom Penh, a place where about 15,000 people were tortured and then wheeled out to mass burial pits and clubbed to death to save them bullets. He was somebody who had essentially confessed to his responsibility, but nevertheless a lengthy trial ensued that involved a lot of testimony, copious documentary evidence. And on the day he was convicted, he was given a term sentence. And the reason he was given a term sentence instead of a life sentence is that the judges had to decide how to deal with the fact that he had been unlawfully detained by Cambodian authorities for years before that hybrid court opened its doors. And the judges decided the only way to make a remedy for that rights violation meaningful would be to start with a term sentence and then subtract a figure that would make it conceivable that at some very old age that he could walk free. And outside of the courtroom that day, there were a lot of emotions going back and forth exactly along the dimensions that Steve is describing. Victims were outraged, just as Bob was expressing as well, outraged that this person who had been culpable for such terrible things could get a sentence of what amounted to about 30 years when he was, only in his late 60s and could conceivably walk free. And then others of us who looked at this and were thinking as human rights lawyers that, well, actually a type of procedural justice was served, that actually this is what one has to do institutionally to be able to stand for the principle that defense rights matter in a system in Cambodia where generally they're not well respected at all. And I'll tell you, Susan, in response to your question, what I felt was, I felt a sense of confusion and even a little bit of a sense of guilt that as somebody who had followed the process very closely and supported it, that I was quite out of touch with where a lot of the victims whom I was purporting to help react, what their reaction was and their sense of justice. They were much more interested in non-procedural aspects of justice, reparation, acknowledgement, apology, and retribution. And I was very much focused, given where I sit, on the questions of procedural justice. To me, the lesson of that was to have a certain humility about how one approaches these things and be cognizant that where we stand will depend heavily on where we sit on questions of justice.
Thank you. I'm not sure how much time we'll have for very many questions. I think we just go till 5:30. So I'm going to combine a couple of questions and see how we go. We've had some questions about the practicalities of the courts. And one is along the lines of a cost-benefit analysis in terms of the money spent. Do you feel that the amount of money, thinking not only about the ICTY, but all of the hybrid courts, are we spending money in the right way? And in many countries, would the money be better spent in by international bodies or others in some better way? And so that's one practical aspect. Another practical aspect is just about fairness, how one addresses it within, say, a hybrid court in Syria, how if it were located in a neighboring country, what steps might be taken by a hybrid court to augment the sense that it was a fair and respectable body. So those two dimensions is kind of like, how do you think about the cost and the benefits, and how do you think about getting maximum buy-in locally? What kind of factors would contribute to that? So whoever.
Perhaps I'll just talk about the cost briefly, and then I'll leave it to my colleagues to talk about whether it's worth the cost. There was an American academic around the time of the Milosevic case, towards the end of it, did a study, and he compared the cost of the Milosevic case against the cost of the Timothy McVeigh case, the Oklahoma bombing case, and the cost was comparable. So both horrible, tragic crimes. Timothy McVeigh, one incident, one day. Milosevic, 10 years, four countries, 3 indictments. So that's the cost. If we're going to do this, and we're going to do it to a high standard, it's going to cost a lot of money.
I basically agree that these things are expensive, and I think that to ask about the alternative, it assumes some things when you sort of say, is it worth it? Because first of all, you can't assume that the money would just, again, as I made in my remarks, you can't just assume the money's just going to get shifted to something else if it's not spent on the tribunals. It's just like you can't say, well, if we just had one fewer aircraft carrier, we could, fund education. It just doesn't work that way in the real world. There's political will, and the money's there, and you can't just shift the money because the political will doesn't shift along with it. The other point I would simply make is the idea that you could just give this money to domestic courts. That's really, really problematic. I certainly wouldn't want to give the billions that went into the ICTY to the Cambodian government. I know what they'd do with it. It would end up in a Swiss bank account, in Hun Sen's private Swiss bank account. You can't throw money at states that don't have a tradition of the rule of law. And so, yes, I certainly, in an ideal world, we always want justice to be at home, but just throwing money at that problem is not going to solve it.
I'll chime in on the question of legitimacy for a court like a regional hybrid court dealing with the Syrian crisis. Extraordinarily difficult, of course, to try to create a sense of balance and even-handedness, since the narratives told by each side pit the other one as the primary offender, right? And so there will almost never be agreement during or after a conflict on exactly where the balance of responsibility lies, and therefore extraordinarily difficult task to ask a court to try to design itself in a way that would seem to be balancing in this way. The prosecutors have to be able to follow the evidence. The evidence doesn't always go a third, a third, a third. And the best, perhaps, that one could do with respect to a regional court for Syria would be to issue an earnest invitation to the various parties to participate and to be able to submit people for consideration as candidates. Assad will say no and boycott it, essentially, as will a number of parties friendly to Assad. And the eventuality will be a tribunal that is relatively easy to present by Assad and Assad's allies as a U.S. or a Western-backed effort to paint events in a particular way. This is a really, really tough problem in a case where you have one of the major parties that is still in a position of power and therefore can't be in some way coerced to participate. So I don't have an easy answer for that. I do think that it would be extremely important, at least to be seen to be making an earnest invitation to various parties to put forward candidates, and also to make an earnest effort in following the evidence, not to selectively, proceed down one line and not the other. If the evidence flows in multiple directions, then people from multiple parties should be in the dock.
Then I'll ask one more question, and I'm going to combine a couple here too. And these have to do with the long-range future and thinking about jurisprudence, et cetera. The beginning of the question is whether you think that there are elements of the ICTY jurisprudence that will eventually, or perhaps already have been, reflected in international customary law, that there are some changes that may appear or be referred to there. And the auxiliary question is about the International Criminal Court and whether we will see in the future that global court will be essentially replaced by regional courts when in the future does it still have a place in the jurisprudence? Was the question of whether there are whether we should expect to see
sure.
Reflection
right.
of.
So I think the lawyer's answer to that question is absolutely. I mean, there's lots of different areas where the jurisprudence of the tribunal is being reflected in customary international law in terms of the definition of armed conflict, in terms of the definition of torture, in terms of issues of state responsibility. There are lots and lots of ways in which that is very, very influential. So I don't think there's much question about that. I mean, on the ICC, it's another panel. we can't really do it all this afternoon. I don't see the idea. I mean, there is the possibility of some regional criminal courts, blossoming alongside the regional human rights courts. I think the ICC is sort of, you know, where the action is right now for the long term in fully international courts. The hybrids, I think, will continue, but in terms of the fully international ones, I think the ICC is sort of where it is. And it has many, many challenges, not the least of which is that many, many important states are not parties to the statute. And it has gotten off to a rocky start, but with some successes already.
On the ICC, I'm not myself very concerned that the ICC will just implode and go away as an institution, but I think one can imagine that the ICC can slide toward a model in which it effectively is a court that governments use to outsource cases to go after their political adversaries. This is the simplest and political sort of mechanism through which the ICC exercises jurisdiction. Institutions tend to have a pretty strong interest in wanting to perpetuate themselves, and the path of least resistance is to take referral cases from states that will tend to cluster in cases of deposed dictators and defeated rebel leaders. That would not necessarily mean that the ICC wasn't doing impactful work with respect to those crimes, but it certainly is not the vision for the court that is envisioned in the Rome Statute.
Can I just add to the ICC question? I don't see the ICC being replaced by regional courts, but I think one good compromise, because there's so many benefits to having the court where the crimes occurred, is that when there is a situation, I think the OTP, the Office of the Prosecutor, should open up an office there, be close to the victims, have the witness protection people there close to the victims. And when the trial starts, if security measures permit it, why not have it in a courthouse down in wherever it happens? And I think bringing it down to where the crimes occurred, if security permits it, I think would be really a fantastic idea and would have tremendous benefits for the court.
As I listen to the descriptions of various kinds of courts and the struggles that they're having, you realize that this is actually a market economy. You have all these different courts sort of competing for funds and for attention and support. And so chances are that many of them are going to fail. And I'm not sure that's bad. The big central player, of course, in this is the ICC, which is, to say the least, sluggish. And in my view is really hobbled by their model, which is that they can sort of go anywhere in the world and don't have to worry about too much about the culture or the language or whatever else is going on, and just sort of adjudicate things based on law and take 10 years to do it, but eventually get out. That, I think, is not a sustainable way to operate. But I think that in the long run, I think the market, such as it is, or semi-market, is probably going to determine those things. And I think there is an important role for, let's say, a centralized international referee or reference service, perhaps even coordinating agency that will somehow manage to coordinate the activities of these various bodies.
Well, I kind of wish we could go on for a while, but we've really come to the end of the time. So I want to thank you again to all the panelists for very interesting presentations and conversations, and thanks to you for your questions. So